Good evening to all of you. Thank you, Prabha, for your kind introduction. The topic that I will address you today, recent amendments in regard to the notarial practice. The recent amendments are Notaries Amendment Act 31 of 2022, Act number 6 of 2024, Power of Attorney Amendment Act 28 of 2022, and Act number 3 of 2024, and Wills Amendment Act 20 of 2022, and Registration Documents Amendment Act 32 of 2022. So before I commence my lecture, I like to give a brief introduction why these amendments were brought in. As you all know, original ordinance pertaining to these acts are more than 100 years old. Just to give a simple example, Notaries Ordinance 1907, Power of Attorney Ordinance 1902. So due to this Archives Ordinance and due to the lacuna in the law or loopholes in the law, recent past, several fraudulent transactions has been increased. Honorable Attorney General has indicted several notaries island-wide in several high courts. In addition to that, there are a number of complaints against the notaries made to the Fraud Bureau, and some of them have been charged in the magistrate. I am personally aware, as overall chairman of the Professional Purposes Committee, making use of these loopholes or the lacuna in the law, there are a number of frivolous complaints have been made against the innocent notaries. So in this background only, basically either to eradicate or to minimize the fraudulent transaction and also to protect the innocent notaries, these amendments were brought in. In this background, once again I use the same terminology, former Minister of Justice, Honorable Ali Chabri, President's Council, appointed me as a chairman of the committee to look into these acts and appointed a very dynamic, versatile members to my committee who are excelled in the various law fields. Members from the Attorney General's Department, Ministry of Justice, Legal Draftsman Department, Registrar General's Department, as well as Bar Association Sri Lanka. So we had several, well over 20 meetings for a period of 33 months, and having deliberated, having gone through and having discussed, and we put forward our final version or the final documentation of the Bar Association, and having obtained the opinion as well as views of the members of the Bar Association island-wide, we put I can proudly say, a masterpiece paper to the Minister. Unfortunately, the amendments what we put forward were verbatim not accepted. Some of the amendments were rejected. New amendments were introduced. Some were modified. As a result of that only, today we are in this position. So anyway, there is no point of complaining. As a notary, we have to go forward and to do our practice. To make in simple term, today practicing as a notary has become impossible. So in this background only, once again I met subsequently former Minister Dr. Vijaydas Rajapaksa, President's Council, and informed him the difficulties faced by the notaries when they are practicing. As a result of this various lacuna in the law, once again, as well as various confusion, various registrar of lands are giving various interpretation. Various notaries are giving various interpretation. In short, the Registrar General also unable to form one opinion. So in this background, very recently, thanks to the present chairman of the Notarial Committee, Nirodha Kalansurya, summoned a meeting with the officers from the Registrar General Office as well as registrars in the vicinity, Registrar of Lands Colombo, Registrar of Lands Kaduela, as well as Registrar of Lands Dilkanda, and we had a meeting. Today, I am going to deviate my normal presentation. I am going to make my lecture in a different way, try to discuss with you the problems that you are facing. Most of you who have been registered for this lecture, I am personally very well aware, most of them are practitioners, some of them are corporate lawyers, some of them are bank lawyers. you have quite a lot of problems are there. So therefore, I will commence my lecture putting forward your problems and what are the answers to be for those problems are there. So as I said earlier, we had a meeting with the officers of the Registrar General's Department, and now they have put forward a circular to avoid all those problems, and also to have a uniformity and a one method to in regard to the registration of deeds. So I like to request the Secretary of the Bar Association, Mr. Chatura Gallena, to circulate the circular as well as the covering letter issued on the 5th of September 2024, and also the annex circular to all the participants who are registered for this series of lectures for their benefit. Prabha, I think if you're on the line, kindly ensure that this circular to be distributed among or we email to all of them for their benefit. As the circular is in Sinhala, I will read it, then I will translate into English. It says that it is signed by the on behalf of the Registrar General, for and on behalf of the Registrar General, Mrs. Jagodarachi, Senior Deputy Registrar General. I'll just read the covering letter dated 5th of September 2024. It says, Chatura he Gallenamaya, address to Secretary. Idam Liapadinchi me Karyalia Tula, Upu Liapadinchi Kirima Sandavu, Kari Patipati, Anugamne Kirimati Atuena, Apasuta Sambandin, Ukta Karno Sambandin, Obavisi Nevanalada, the Das Visiatre, Hatai Danamea, Lipia Bende, Emma Lipia Samagamuna, Chakla, Ketumpata, Upades Lipia Klis Sakaskra Mesam. So basically, what the Assistant Registrar, the Senior Assistant Registrar General has said is address of Secretary to this particular circular will be circulated among all the land registries to have a uniformity. And I will now back again the entire circular also in Sinhala. I will read in Sinhala for the benefit of others. I will translate into English. The one of the biggest problem that after this amendment came in, what we are facing is most of the deeds when we tender to the land registry, at the counter itself it is rejected. And just for you to know, IU drafted the entire circulator, but Registrar General was kind enough to accept same in verbatim without making any alteration. So I know the exact reason behind why this was drafted there. So I'll read it again. So I think one of the main problem that we faced in the land registry is most of the registrar of land look at the document at the counter, reject it. Now in view of this circular, the deeds cannot be rejected. If you do have a copy of this, you can take it to the respective land registry and tell the registrar of land, the respective registrar of the land, that you cannot register. There is a circular issued by none other than the Registrar General. I just read the document. Number 1, Liya Padinchiya Sandha Idiripat Karna Sam Oppuakma Evaye Adulindukan Pariksha Nokara Baragata Yutu Atara Emo Oppu Idam Liya Padinchiya me Karyaledi Counter Edima Patikshepa Nokala Yutia. Any deed which has been handed over to the land registry for registration, irrespective of whatever the shortcoming, that has to be accepted, cannot be rejected. That's first thing. Emma oppu bara ganimen anaturuwa evaayati dosha ho evaye moneyam adalundukamak etnam pasuwa e sandan karmin e oppu liyapanchi kirima pratikshep kirima pasuwa sidhu kala heka. Having accepted the deed, if there are any shortcoming, having set out what the shortcomings are, registrar is the respective registrar of land is entitled to reject it. But when we had the discussion with the Registrar General, officers as well as the several officers from the respective land registry, one of the big complaints that they made was there is no prior registration mentioned in the deeds. In that regard, I am sorry to say, the entire blame should go to the notary for the simple reason. Look at in view of the new amendment, I think deviating the circular and I'm going for the thing. One of the main salient features in the amendment to the notary's ordinance is section 31 subparagraph 17b. What has it done there? It has made mandatory to do a search prior to execution of the deed. Today, the most important thing, the prime duty of any notary when a deed is handed over, to do a search in the land registry. It only mere to do a search, having done a search, you have to obtain the last entry. Not only you have to obtain the last entry in from the land registry, you have to insert the last volume, folio in the new deed but you execute. So if deed is rejected or if the deed is returned without accepting, you should be thankful to the relevant officers for returning the document to correct it. I think in a situation like this, if a land registry say, look, the prior registration is wrong, and notwithstanding the fact, if you do argue and say, circular says no, you should accept and go through, reject it later, you have to go through massive process of section 35 by way of an appeal. Therefore, first and foremost thing what the notary should do is, before arguing with the relevant registrar, you have to adhere to the law. Otherwise, you are violating section 13, subparagraph 17b. It says it is mandated to do a search at the prior to the execution. Not only it's mandated to do a search, you have to check the relevant folio volume and also obtain an entry. Not only you have to, that doesn't stop with your responsibility, you have to insert the correct volume folio. So therefore, although the registrar has a power to accept notwithstanding any shortfall, assume if a volume folio not mentioned, that is a violation of the notary's ordinance that the notary is doing, and therefore ensure not to make that kind of a mistake. Put the correct volume folio. In view of this circular, land registry may accept, but having accepted, you have to go, first of all, you are violating the law. Number two, if it is accepted with a wrong folio, wrong volume, you have to go through the ordeal of going through section 35 of the notary's ordinance, appeal. So therefore, first and foremost, notary should do notary's duty before finding fault and say don't reject it. That's number one. Number two, 2024 අංක 6 දරන නොතාරි සංශෝධන පනත අනුව ලියාපදිංචි කරන ලබන මුල් පිටපත් සඳහා ඡායාරූප රැඳවීම අවශ්‍ය නොවේ. එබැවින් ලේඛන ලියාපදිංචි කිරීමේදී ඡායාරූප පිළිබඳව සලකා බැලීම අවශ්‍ය නැත. I think as all of you all are very well aware, in terms of section 31 subparagraph 17b3, there are 4 kinds of deeds where it has been made mandatory to affix photograph. What are the things? Deed of transfer, deed of gift, deed of exchange, and last will. Back again, as I told you earlier, our committee suggested these photographs to be affixed to the protocol. Why? To protect the notary. There are several instances where client come and sign the document and subsequently deny coming to the office. And therefore, to protect the notary, only we suggested. In the original Act number 31 of 2022, they made a mess of it, and finally what happened, they said affix to the original, going against the advice given by our committee. As a result of then what happened, when say for example hierarchy, maybe a politician, maybe a judicial officer, maybe some well-known business person in the society purchase a property through land registry, it will go to the social media, whole country will get to know, your privacy is affected. And that is the very reason we suggested no affix to the, or not to the original protocol. Thank God, now after meeting the former minister, Dr. Vijayadasa Rajapaksa, President's Council, now that situation has been changed. Now the protocol, photograph to be affixed to the protocol. That is why it says, in regard to the registration of the deed, there is nothing for the registrar of lands to look at whether photographs have been affixed or not. Why? The notary should affix the photograph in regard to deed of transfer, deed of gift, deed of exchange, last will, only to the protocol and not to the original. So that is the second one there. It says, 2024 අංක 6 දරන නොතාරි සංශෝධන පනතට අනුව ලියාපදිංචි කරන ලබන මුල් පිටපත් සඳහා ඡායාරූප පැළවීම අවශ්‍ය නොවේ. එබැවින් ලේඛන ලියාපදිංචි කිරීමේ ඡායාරූප පිළිබඳ සලකා බැලීම අවශ්‍ය නැත. It is correct, but it is the prime duty and the responsibility in terms of the Act number 6 of 2024 to affix that photograph to the protocol. Why do we bring that law? To protect the notary. That's the second one. Third one, 2024 අංක 4 දරන වංචා වැළැක්වීමේ සංශෝධන පනත ප්‍රකාරව ගැනුම්කරුට ඔප්පු හෝ සාධන පත්‍රය ලියා අත්සන් කිරීමට නොහැකි වන අවස්ථාවකදී ඔහු විසින් තමා වෙනුවෙන් එම ඔප්පුවට හෝ සාධන පත්‍රය අත්සන් කිරීම සඳහා වෙනත්නම් තැනැත්තෙකුට ලිඛිත බලය පළවන ලැබිය අතර එකී තැනැත්තා නොතාරි ආඥාපනතේ දක්වා ඇති නියම වලට අනුකූලව කටයුතු කළ යුතුය. So according to that section, it says in terms of the amendment to Prevention of Frauds Ordinance 4 of 2024, in case, because we have brought a new law, in terms of the new law is earlier law according to the old 7 of 1907 ordinance, only the seller signs. Only the seller, a person who is selling the property sign. Now we have insisted purchaser also to place the signature. So section, this particular fraud, Prevention of Fraud Ordinance amendment says, in case if a purchaser is unable to place the signature, he can authorize. Back again, there is a lacuna in the law. What kind of authority? Whether it should be a notarial document. Correct form would have been if a person is out of the island or unable to get a power of attorney. But of course, law here, according to this, says balaya power on Libya. So, what kind of authority? Whether it should be notarial, whether meets and bounds should be mentioned. Back again, there is a lacuna in the law. But anyway, the law of the land is whether we like it or not, we have to accept. But they say authority. So, in my opinion, when you say authority, at least the transaction should be surface in there. At least say, I so and so, who is the intended purchaser, hereby authorize so and so to sign for and on behalf in regard to purchase of this property. If you can give the metes and bounds, and there it doesn't say anything. He says in terms of the notary's ordinance, it doesn't say. So it has to be normally in terms of section 2 of the Prevention of Frauds Ordinance. It has to be a notarial document, correct, but strictly. But of course, land is not following. That's back again. Land is having lot of problem. What kind of a documentation? When you say letter of authority, what kind of authority? What that authority should contain? Whether it should be a registered document. So I think the most appropriate thing is to obtain a power of attorney. The power of attorney will say who is the intended purchaser. He is appointing an attorney to purchase the property for and on his behalf, sign the document, sign the agreement to sell, as well as it will have the metes and bounds. But anyway, there still again I must say there is a lacuna in regard to that issue. It's not clear in terms of the amendments to the in regard to the Prevention of Frauds Ordinance. If that person can't sign, he can give authority. What kind of authority? It doesn't say at all there. But of course, land registries generally follow if the expression, if the intention of the purchaser is clearly set out by that document, that would suffice. Next one, තෑගි ඔප්පුවකදී තෑගි ලැබුම්කරු බාලවයස්කරුවෙකු වන විටදී එකී බාලවයස්කරු වෙනුවෙන් මව හෝ පියා හෝ අධිකරණය පත් කර ඇති නෛතික භාරකරුවෙකුට ඔප්පු අත්සන් තැබිය යුතුය. So in regard to a deed of gift, as you all know, a minor doesn't have a capacity to sign any documentation. In such event, on behalf of the minor, the guardian, that is the father or the mother or a lawful guardian who has been appointed by court. Adhikaranayen pat kar labu naithika bharakaru. A person who has been appointed by court. If it's a father or mother sign, that doesn't, no problem. But you can't get any other person to sign in terms of the law. You have to get a person who is a legal guardian appointed by the court. Next one, 2024 අංක 4 දන්න වංචා වැළැක්වීම වගන්තිය ප්‍රකාරව ගැනුම්කරු බාලවයස්කරු කියන බාරකරු මේ පන්ති කාර්යසඳ බාරකරු මේ පන්ති කාර්යසඳ ගැනුම්කරු වෙනුවෙන් ක්‍රියා කිරීමට ශක්නුතාවය ඇති තැනතු. So he said he is in case if a purchaser is a minor, in such event guardian, back again I think guardian mean but it meant is a lawful guardian. So if somebody going to purchase a property, he has to have a legal guardian if the property going to be in minor's name, because even in the attestation you have to say for and on behalf of the minor, guardian so and so paid the money. So therefore you have to have a person duly appointed by court, otherwise it says බාරකරු මේ පනතේ කාර්යසන. So it has to be a guardian lawfully appointed. Next one, යම් ඔප්පුවක හෝ සාධන පත්‍රයක නොතාරිස්ගේ නම තිබීම අවශ්‍ය නැත. මුල් පිටුවේ මුල් අකුරු සමග තිබීම ප්‍රමාණවත්ය. එසේ වුවද නොතාරිස් සාතිකයේදී නොතාරිස්ගේ සම්පූර්ණ නම තිබේ. Now this is another very unwanted thing introduced by the original act, saying full name. Now take a person, especially there are certain people who live in certain area, they have very long surname. You take a person who lives in Kandy. I think I have come across people who have almost like A to Z, all the 26 alphabets are there, A, B, C, D, so and so, so and so. So the fact is that in a person of that thing, his entire first page of the deed will go to his name. If you say put the full name. Especially there are certain, especially in Kandy I have come across, their names are so long. Their Vasagama, so many surnames are long. I have come across some people have 15, 20, more than that names are there. So that is the very reason, so by the subsequent amendment, where now you say mere initial would suffice. Now even in the land registry, we are not known by our full name, known by their name, by their initials there. So that is the very reason amendment has been brought in. Now say the full name is not necessary in the first page, but initial would suffice. But having said, it has been stated here, in the attestation, full name has to be there. But don't forget the fact it is not here. None of, I think most of who are listening here, I'm almost certain, most of you will not follow with the full name, office address has to be there. Because if you look at the amendment to the Notary's Ordinance, even Act number, the first Act 31 of 2022, the specimen attestation very categorically states full name and the address of the notary. So most of us, when I check with most of these land registries, they say they ignore and register, but that is one of the mandatory requirements. You can check the people who have joined this discussion today, how many of you all are putting with your name and the address. I can say most of the people are not doing. So therefore, that is one of the requirements. එසේ වුවද නොතාරිස් සාතිකයේදී නොතාරිස් වරයාගේ සම්පූර්ණ නම තිබිය යුතුය. සම්පූර්ණ නම ප්‍රමාණවත් නැහැ. කාර්යාලයේ ලිපිනයත් අනිවාර්යෙන් සඳහන් කළ යුතුයි. You should mention not only the name of the notary's full name and also address also you have to mention. Next one. යම් පැවරුම් ඔප්පුවක් හෝ තෑගි ඔප්පුවක් අත්සන් තබන ලද්දේ ඇටර්නි බලකරුවෙක් නම් එවැනි අවස්ථාවකදී සංශෝධන පනතේ 31 තිය වගන්තිය ප්‍රතාරව මුල් පිටපත අනුපිටර සහ නොතාරිස් පිටපතට ලැබිය යුතු සත්‍ය පිටපතක් මිස ඇටර්නි බලපත්‍රයේ සාතික පිටපතක් නොවේ. This is also once again a chaotic thing introduced by the original amendment. What do they say in the original amendment? When you are doing a deed based on a power of attorney, a mere, even original you can't annex. Look at the difficulty what a notary has to go through. You register the power of attorney, you send the Registrar General Office the original power of attorney. You register it. That would not suffice. You can't even annex the original. Once it is power of attorney is registered, addition to that, you have to take the trouble and apply for another certified copy. And the certified copy, only you have to annex it to the documentation. Now back again, that situation has changed. It says that if we do annex a true copy certified by a notary, that would suffice. I'll read it again. යම් පැවරුම් ඔප්පුවක් හෝ තෑගි ඔප්පුවක් අත්සන් කරලා ලබද්දී ඇටර්නි බලකරුවෙකු නම් එවැනි අවස්ථාවක සංශෝධන පනතේ 31 තිය වගන්තිය ප්‍රකාරව මුල් පිටපතට අනු පිටපතට ඒ නොතාරිස්ගේ පිටපතට ඇමුණුම් ලැබිය යුත්තේ ඇටර්නි බලපත්‍රයේ සත්‍ය පිටපතක් මිස සහතික පිටපත. So not a certified copy, mere true copy from the original by the notary would suffice. There is no necessary. Up to this amendment came in, it was mandatory. In addition to you get the original registered, you can't even put the original there. He said no, law says it is there. So this, as I told you, these were the things what we put forward to the committee, put forward to them, and subsequently it was rejected or modified. As a result, only all these chaotic things have happened. Next one. මුද්දර ඇලවීම මගින් මුද්දර ගාස්තු ගෙවන ලද ලේඛනයක දෙවන පිටපතේ සත්‍ය පිටපතක් සමග මුල් පිටපත ලියාපදිංචි ඉදිරිපත් කරන ඒ බාරගෙන බෑ. Can you hear me? මුද්දර ඇලවීම මගින් මුද්දර ගාස්තු ගෙවන ලද ලේඛනයක දෙවන පිටපතේ සත්‍ය පිටපතක් සමග මුල් පිටපත ලියා බලන්න. Now there back again, I think all these things corrections happen due to the error or the mistakes made in the original act, as I told you.
You have got muted there, Mr. Arulpragasam. You have accidentally got muted.
Muted. Sorry. Yeah, can you hear me now?
Yeah, we can. Now can. Yes.
Right. Sorry about it. Extremely sorry. Come on.
Oh, wait, I didn't know.
Right. This now back again. I will read this one there. මුද්දර ඇලවීම මගින් මුද්දර ගාස්තු ගෙවන ලද ලේඛනයක දෙවන පිටපතේ සත්‍ය පිටපත සමග මුල් පිටපත ලියාපදින ඉස්පත් කර ඒ බාරගෙන. Now in the, as I told you, these all the various things were newly introduced by to our committee suggestion. That's why all this problem happened. Now there again, what the law, initial law says, that an amendment came in. According to that, what is recognized and accepted if a deed has been executed and paid the stamp duty to the bank and obtain a receipt. Now, for example, what happened to the adhesive stamp? Say for a small deed, maybe 5,000, 10,000 rupees value of the thing, and you are fixing 100 or 200 rupees. That kind of a documentations are not accepted. So by this we say, muddara alavima magin muddara gastu given lada dekane. So even stamp duty paid by adhesive stamps are accepted. By the earlier amendment, no. If you have not paid the stamp duty to the bank and obtain a receipt from the bank, it will be valid. Otherwise, that document is not valid. So now that again has been amended. Even a stamp duty paid by purchasing stamps and affixed to the deed will suffice now. Next one. කිසියම් ඔප්පුවක් කොටස් වශයෙන් සහතික කොට ඇති විටක එකී ඔප්පුව නොතාරිස්වරු දෙදෙනෙක් විසින් සහතික කර තිබීම හෝ එකම නොතාරිස්වරයා විසින් දින දෙකකදී සහතික කිරීම යන නොතකා එවැනි ඔප්පු බාරගත යුතු අතර ලියාපදිංචි සඳහා දින 30ක කාලය ගණන් කිරීම සිදුවිය යුත්තේ පළමු ලියාපදිංචි කළ දිනේ සිට නොව දෙවන. Now the another issue is in regard to this land registry, part attestation not accepted, where the law says, not today, yesterday, 1907, Notary's ordinance says part attestation accepted. So when you do a part attestation, now say for example, as a notary, you are doing a lease agreement. You act for the lessor. And then what happens is, whatever the money transaction, lessee paying and all that will happen on a particular day. Now say for example, in month of, now say today we are 13th of February, we are doing 13th of February, stamping done, all that done. Because the first part of the attestation has to be done by the lessor's lawyer, collect the necessary stamp duty fees or whatever the payment in regard to the deposit or any other thing, all set out, and first part of the attestation will be done. Then you have your, when you do it there, you have your, put your number and hand it over to the respective, the second notary who is going to do the part attestation. So when that person put a part attestation, that particular notary / with your number, put another number, and he say, I further certify and attest, so and so signed in front of me. Now the question will arise, when will if it's a deed executed within your jurisdiction where you are practicing, not outstation, then question of 30 days issue will come. 30 days will arise from the date of the second attestation, not from the day of the first attestation. Back again, I think there were issues raised by the officers from the Registrar General as well as from the land registry. What is the time gap? Now say for example, a deed is mandatory, good old earlier 1907 law, when you send the deed for registration, what you got was a priority. Today it is mandatory. It's a mandatory, otherwise it's an offence. Now the question arises, what is the time limit? Now when you do a deed in month of February, can it be after 6 months? So those are things to be still, I think, to be cleared, and those lacunas to be filled now. So now, irrespective of that, now we'll say in regard to a principle of partly attested, now is permitted. What do they say? The question arose in regard to how these 30 days are counted. 30 days are counted from the date of the second deed, not from the date of the first deed. I read it again. කිසියම් ඔප්පුවක් කොටස් වශයෙන් සහතික කොට ඇති විට partly attested. එකී ඔප්පුව නොතාරිස්වරුන් දෙදෙනෙකු විසින් සහතික කර තිබීම හෝ එකම නෙතාරිස්වරයා විසින් දින දෙකකදී සහතික කර තිබීම යන නොතකා එවැනි ඔප්පු බාරගත යුතු අතර ලියාපදිංචිය සඳහා දින 30ක කාලය ගණන් කිරීම සිදු විය යුත්තේ පළමු ලියා සහතික කළ දිනේ සිට නොව දෙවනුව ලියා. So we had issues. There were several, because I get calls from island wide from various notaries in regard to these problems. So based on that only I prepared these documents and given. Now the question is, in principle, now part attestation accepted up to till the circulation went in, most of the land registries reject and say no, there is nothing called a part attestation, not recognized. Now it is recognized, and the point what I want to stress here is 30 days count from the date of the second deed, not from the date of the first deed. Next one, yam parshavayak visin see atsana ඇඟිලි සලකුණ තබා ඇති විටදී එකී ඇඟිලි සලකුණ තැබිය යුත්තේ අත්සට පසකින් ඕ ඉහළින් වන අතර එය කාගේ ඇඟිලි සලකුණ යන දැක්වීම අවශ්‍ය නොවේ. කෙසේ වුවද අස්සන වෙනුවට ඇඟිලි සලකුණ පමණක් ඇති විට එවැනි අවස්ථාවකදී ඇඟිලි සලකුණ දෙවතාවක් තැබිය යුතු අතර සාධන පත්‍රය ඇත්තේ කාගේ ඇඟිලි සලකුණ. Now that's the other issue. Now the law in regard to this new amendment which came in Act number 31 of 2022, couple of mandatory requirements were there. From 1907 up to 2022, 115 years, the practice hitherto adopted was only the party's signature, that is only the relevant person's signature. In good olden days, you get the fingerprint when you are illiterate. When you are not an educated person, you can't keep you don't know how to place your signature, and therefore this law, they say if a person illiterate and unable to sign, it can you get the fingerprint there. Normally in our sense, we say fingerprints are kept by IRC, like a convicted criminal. Only when a person is convicted, the respective High Court judge say, go and give you a fingerprint. So I could nothing to do with this. I like to narrate an interesting story there. I think couple of years ago, I think when former Minister Mangala Samaravira, he was Minister of Foreign Affairs at that time, when the High Commission, British High Commission first time introduced the fingerprint, he filed a fundamental right application and said they violating the fundamental rights of the citizens of the country, are not willing to keep the signature. But of course subsequently it became the norm, or all over the world the fingerprint is a must there. And there again you will be interesting to note. Now come back to a signature, you can forge the signature, EQD's opinion could differ, but look at the God's creation, two people fingerprint won't be equal. We call biometric there, and that is the very reason to avoid fraud. Not that all the crowd is illiterate and we introduced this fingerprint. Fingerprint was basically introduced to eradicate fraud, because when your fingerprints are there, you can easily think two people fingerprint won't be there. Through biometric method, you can immediately catch and see whether this is genuine or not. So now come back to that issue in regard to fingerprint. Now the land registries are insisting and say once you put a fingerprint, again say whose fingerprint is. There is no necessity. You put the signature, and either it is above or besides, the fingerprint is there. It is common sense understood whose fingerprint is. The only occasion that you have to explain whose fingerprint is when a person is unable to sign, either uneducated or not in a position to sign due to some physical inability. You have to get the fingerprint twice. What is the first fingerprint? That's a signature. In that instance, you have to say, this is the signature of so-and-so. Why? Instead of placing the signature, that person is putting the fingerprint, not otherwise. I am personally aware, so many land registries in the vicinity says, no, you have not said whose signature. Not because that's why I am giving this circular to you. Please, all practitioners, ensure to get a copy from the Bar Association and show them there is no necessity, unless otherwise somebody places his signature as a fingerprint because unable to sign or physical disability. I'll read it again. Yam parshya visin see atsana sa ඇඟිලි සලකුණ ඇති විටදී තබා ඇති විටදී එකී සලකුණ තැබිය යුත්තේ අත්සනට පසකින් ඔයලින් වන අතර එය කාගේ ඇඟිලි සලකුණද යන්න දැක්වීම අවශ්‍ය නොවේ. කෙසේ වුවද අත්සන වෙනුවට ඇඟිලි සලකුණ පමණක් ඇති විට එවැනි අවස්ථාවකදී ඇඟිලි සලකුණ දෙවතාවක් තැබිය යුතු අතර සාධන පත්‍රයේ ඇත්තේ කාගේ ඇඟිලි සලකුණද යන්න දැක්විය යුතුය. So basically, what is the circular says here? When a party keeping the fingerprint, it should be beside or above. In normal practice, hitherto adopted, we generally say left thumb impression. But X says now any thumb impression. So it's not mandatory. But of course, in the attestation, when you are putting it, you must say whether it's right or left thumb impression you have to set out. But it's very clear now, there is no necessity at all to say whose fingerprint is. Understood, common sense, because either you do it beside or above. For all purposes, it's clearly said, and also in the attestation it says this is so and so. Therefore, there is no necessity to say whose fingerprint is. Why I am saying this? So many lawyers notaries have spoken to me from various parts of the country. So I have to speak to the respective registrars and tell, look at, please follow your guidelines or circular issued by them. Then they register it. So there is no necessity. But of course, only on the instant, instead of placing the signature, if somebody's signature is going to be a fingerprint, in such event, you have to say whose fingerprint is that. Why? He signs twice. First he signs by way of a placing signature because he is physically unable or illiterate in such situation, not otherwise. Therefore, please understand there is no necessity to explain and say whose fingerprint is. Next is යම් attorney බලපත්‍රයක් හෝ attorney බලපත්‍ර ආඥාවට අනුව කළ සංශෝධනයට පෙර ආතුව එනම් වර්ෂ 2022 ඔක්තෝබර් මාස 25 වෙනි දිනට පෙර ලියා සහතික කරන ලද්ද අංක 2022 අංක 28 දරන attorney බලපත්‍ර පනතේ අන්තර්කාලීන විධිවිධාන ප්‍රකාරව එම attorney බලපත්‍රයෙන් ප්‍රත්‍යාදිෂ්ඨ කිරීම අවලං කිරීම සිදු කරන තෙක් දක්වා ඇති. Now this is another question very often arising from the bank. Now the question is, there is a power of attorney given. In terms of the new power of attorney ordinance or rather act, power of attorney is valid for 5 years. Now they posed a question whether this power of attorney given prior to this amendment came in by operation of law. Ipso facto, whether it is ceases. No. Transitional provisions will apply very clearly. It says section 8 subparagraph 2, when I deal to the power of attorney, I'll deal with that section where it categorically says in regard to the power of attorney, it says section 8b, where a power of attorney has been duly registered in terms section that which have not been revoked prior to the amendment in that shall continue to be valid until revoked or cancelled in terms of section 4 of this act. So if a power of attorney has been given prior to this law came into operation, in short, prior to 25th of October 2022, it could be irrevocable. There is nothing at all. Still, it will be valid and in force in terms of section 8 subparagraph B of the Amendment Act, that's called a transitional period, and until otherwise that particular power of attorney is revoked or cancelled, it will continue. So, most of the people get confused and say, look, the law says power of attorney is valid for 5 years. Now this has been done 10 years ago. But the law is retrospectively applying in regard to this specific provision given. Now say for example banks. So banks can't function if this kind of provisions are not there. So we have thought all this. That is the very reason we brought this transitional provision. According to this, if any power of attorney has been given prior to 25th of October 2022 and that power of attorney is not cancelled or revoked, in such event that power of attorney continue to be in operation notwithstanding the fact new amendment has come in. So that's the law. The next one, 2024 අංක 3 දරන ඇටර්නි බලපත්‍ර පනතේ 4A2 වගන්තිය ප්‍රකාරව යම් ඇටර්නි බලපත්‍රයක් ශ්‍රී ලාංකිකයන් පිට සාධික කරන්නේ නම් සාක්ෂිකරුවන් දෙදෙනෙකු ඉදිරියේ අත්සන් කිරීම අවශ්‍ය නැහැ. Back again, I don't want to say go again and again this how chaotic these amendments have been brought in. Back again, this is another unwanted thing. People are abroad. Take for example a housemaid going before a high commissioner or an ambassador to get a goods what is sent to Sri Lanka to be released through some cargo person. What has he got to do? He has to pay somebody, another 2 people as witnesses, pay money and take them to the embassy and get their signature. Now that situation doesn't arise. When it's come to a question of foreign power of attorney, the question of getting 2 witnesses no longer needed now. attorney බලපත්‍රයක් attorney බලපත්‍ර පනතේ 4A2 වගන්තියේ විධිවිධාන ප්‍රකාරව ශ්‍රී ලංකාවේ පිට සාතිකන් සාක්ෂිකරණ දෙදෙනෙකු ඉදිරියේ එය අත්සන් කිරීම අවශ්‍ය නොවේ. In terms of section 4 subparagraph B2, there is no necessity in regard to foreign power of attorney to get two witnesses' signature. So keep that in mind. Next one, තෑගි ලැබුම්කරු රටින් පිටත සිටීම මත ඔහුට හෝ ඇයට අත්සන් තැබීමට නොහැකි විටදී තෑගි ඔප්පුවක් හෝ තෑගි දුමනා කර පමණක් අත්සන් කොට ඇති විට එවැනි ඔප්පුවක් බාරගත යුතු අතර එකී තෑගි ඔප්පුව පසු අවස්ථාවක තෑගි ලැබුම්කරු තහවුරු කිරීමේ ඔප්පුවක් deed of confirmation කරගත. Now this is another problem very often we face. I have faced this problem many occasions. Now a mother is ailing or want to give a property to the child is abroad. Now when you do a deed of gift, only the donor signing, land is rejecting. He said gift should be an offer and acceptance. No doubt parents are gifting, there is nobody to accept. So I told several registrars of the land, I said, what is the use of having this document called deed of confirmation? The confirmation is there subsequently to confirm it. So therefore, please understand that you can unilaterally, one person can give it, the deed of gift to the other property, notwithstanding the fact the person who is not not in Sri Lanka or available to him. But having said that, you have to understand a deed of gift will not be a valid instrument because it is an offer and acceptance. I am giving the something as a gift to you, and if you are not willing to accept, it won't be fulfilled. So as far as the deed of gifts are concerned, deed of gift can be gifted without the donee present in Sri Lanka or without donee signing, and subsequently you can give a effect or power to that particular document by doing a deed of confirmation. But having said that, I will repeat it and say, if a deed of gift has been given, if the donee is not accepting, that's not a valid instrument because it's only a unilateral thing. Documentation, it won't be valid in law, but of course you could execute. But of course you have to be very cautious when you are drafting the deed of gift. Don't ever say, because there are instances where one side signing, but there is a clause in the deed itself, don't hereby thankfully accept, and nobody has accepted. You can say there as donee is out of the country or will be done by way of subsequent deed of confirmation, some kind of a recital you can put to the effect. Don't put a recital to the effect to say donee hereby thankfully accept the gift. Not accepted. And therefore don't make that kind of a wrong statement there. So තෑගි ලැබුම්කරු පිටත සිටීම මත ඔහුට ඇයට අත්සන් තැබීමට නොහැකි වන විටදී තෑගි ඔප්පුවක් තෑගි දීමනාකරු විසින් පමණක් අත්සන් කොට එවැනි ඔප්පුවක් බාරගත යුතු අතර එකී තෑගි. So you can tell the land registry, if only the donor sign, you have to accept notwithstanding the fact. Subsequently, by way of deed of confirmation, that can be accepted, provided to get the validity, both have to sign, otherwise it won't be a valid document. Next one. ලියා අත්සන් කරන්නා යන වචනය වෙනුවට යන වචනය මේ වන විට 2024 අංක 6 දර නොතාරිස් පනතේ 40 වෙනි වගත්තේ ඉවත් කොට ඇති බැවින් පාසඳාන් ඔප්පු සාධන පත්‍ර සඳහා අත්සන් කළ යුතු එක් පාර්ශ්වයක් පමණි. ඇටර්නි බලපත්‍රය ඇටර්නි අධිපති විසින් පමණි, ණය උගස්කරු විසින් පමණි, පොල්මන්කාර පැවරුම්කරය පොල්මන්කරු විසින් පමණි, administrative පැවරුම්කාරය administrative පමණි. Once again, a chaotic thing that was introduced by the original act. What does the original act say there? The interpretation to the word executant. Executant, they used the word all parties. When you say all parties, executant means in relation to a deed of transfer, the transferor and the transferee, in relation to the other instrument, the parties to such deed or instrument. So when it come to a question of in vivo those amendment, when it came to a question of a power of attorney, they said principal also has to sign, attorney. How can a person legally possible? Say for example, if a principal is in UK, attorney is in Sri Lanka, how can you do that? Similarly, you can't. Similarly, mortgage. Banks are giving mortgage to us. Why should the bank sign? The person who is giving the mortgage, why should they sign? Similarly, in regard to executors conveyance, I don't want to say, certain land registries say no, the beneficiaries have to sign. So now that particular things have been changed in regard to powers of attorney, in regard to mortgages, in regard to executors conveyance, administrators conveyance, it's only the respective one party, not the all others. Because why? that particular word called executant now deleted from the interpretation of section 43. It is deleted. Now it's no longer there. Then the next one, 2024 අංක 6 දරන සංශෝධිත පනතේ 38 වගන්තිය ප්‍රකාර කොන්දේ සහිත පැවරුම් කර ලියාසා කිරීම සඳහා නීතිමය බාධාවක් නොමැති බැවින් ලියාපදිංචි සඳහා දෙන ලබන ඔප්පු බාරගත යුතුය. Now this is a very crucial and dangerous amendments have been brought in to section 38. Now according to section 38, I read it. It says, it's very crucial one. It shall be duty of every notary to endeavour to ascertain the true legal nature of the transaction between the parties and to execute the deed or instrument for the true transaction. B. Specially, expressly explain the executor the true nature and every deed or instrument before any executor such instrument. Next one, he shall not directly or indirectly authenticate, attest or any deed or transfer in respect of the transaction which is in fact mortgage, conditional transfer or any other similar nature. A notary who shall knowingly and willfully execute a deed or instrument in violation of the above shall guilty of an offence not done. Now it's a very, I don't know, I don't think bias or anyone was aware this clause how it came in. This is casting a massive responsibility on the law notaries. What does it say? Now hereafter, when a client coming for any transaction, you have to ascertain how he got the money, whether it's a money laundering. So it's now it has made a paramount duty of a notary to ask, how did you get the money? I think you will lose your practice when you ask these questions. They will go to another notary who is not asking any question. So I think it's very dangerous section. And having said what do they say is that in case you are done a transaction of that nature, you will be liable for 500,000 rupees damages to the penalty for doing that. So I think the whole issue is, I think I'll give a different example. I think what happens is I think what they meant to say is different, but they have in the act what is expressing is different. What they meant, but according to my opinion and my understanding, what they meant is there are instances where a client comes to us and said, sir, madam, this property is worth about 50 million, is asking for a loan of 10 million. Now, how am I to secure? The correct thing, right thing to do is do a mortgage. Do a mortgage the property, then person is mortgaging this amount of money. If there is any interest to be paid, interest will be paid and that. But what does the most of the notaries do? Other way. They convert the deed to protect the interest and the benefit for the particular person who is lending the money. They convert the mortgage into a deed of transfer. And they won't even tell what they are doing. Because as overall chairman of the Professional Purposes Committee, I come quite a lot of complaints against the notaries for the reason because when a man is getting a loan and from the particular respective person who is lending the money, he will sign any document. And most of the occasion, very well-known lawyers, senior lawyers, what they do, they get blank documents, blank papers to sign, and say, what does they say? No, this make a ugas kare, make a banung kare. So they say this is a mortgage, and ultimately they convert the mortgage into a deed of transfer, and thereafter what happens? It doesn't stop with that. Few months later, they will send a notice to quit, file ejectment action. So what they meant is not to convert, that is where in paragraph 2 it says, he shall not directly or indirectly authenticate or attest any deed or transfer in respect of a transaction which is in fact a mortgage or a conditional transfer or any other similar instrument or deed. So basically what the act envisaged is you do the true nature of the transaction. But I am aware there are so many complaints have come. I have gone through the thing completely. So the fact is what they do is they convert it to a mortgage or a now there are instances conditional transfer. What is conditional transfer? Conditional transfer say, now say for example, X is in a difficulty to we want to borrow some money, right? So he transfers the property. But having transferred, he makes a particular clause and say, okay, now I am giving this for 10 million to you. Give me within 1 year's time with 2 million interest, I am willing to repay. Put that in the deed. Those are permitted. Those are permitted. In case if something goes wrong, you can go to debt conciliation board and your clients can get the property back again, things done. So, but if you do fail, then you will lose your property. But what do the notary do? They convert the mortgages into a deed of transfer, which you should not do. That is where they say, if the nature is transaction, and owing to this section, what happened now? Not a single land registry, personally aware, so many land registries are rejecting to get any conditional transfer done. Mortgages, there is no issue, it's permitted. Conditional transfer, none of the land registries are accepting. He said, section 38 doesn't permit to do a conditional transaction, conditional transfer there. So that is where now the circulars very clearly says, Didas Visiatare, අංක 6 දරන නොතාරිස් පනතේ 38 අයන්න 1 2 වගන්තිය ප්‍රකාරව කොන්දේසි සහිත පැවරුම් කර ලියා අත්සන් කිරීම සඳහා නීතිමය බාධාවක් නොමැති බැවින් ලියාපදිංචි සඳහා දෙනු ලබන උපු බාරගත යුතුය. So the question that you have to, the thing that you should know is, you should know the true nature of the transaction. Don't deviate and don't commit an offense just to protect the interest of your client. It is illegal, wrongful. Don't get signatures on blank documentation. Don't convert the mortgages to a deed of transfer for the benefit of your client. You have to face far-reaching consequences. The consequences I need not tell you, you know. In the event of a complaint against a notary to the Supreme Court, after inquiry, in the first instance, your license may get suspended or license may get cancelled. Now, in terms of the new law, you section 39 subparagraph G, you have to face rigorous imprisonment. It's earlier 5 years, now it's 10 years. And you can see at a rate from recent past, so many notaries' licenses are being cancelled. So many notaries are getting into difficulty. So be very careful, because it's a noble profession, good profession, but don't misuse these acts are there. Don't take loopholes in the act and commit more offences. These amendments are being brought in to protect the innocent notaries and to eradicate or reduce the fraudulent transaction. So don't be a party to these things are there. So that is in regard to that. Then another crucial thing, most of the people, most of the notaries, they do not follow the Notaries Amendment Act, especially the attestation. So it's not like earlier. The earlier we had an issue in regard to section 31 subparagraph 9. When we execute deed, we should know either the executant or the executant person, basically the seller or the witnesses. So look at the practical side. This was the law in 1907. Well, I can't find fault. With the 115 years, with the passage of time, things have changed. Now, what was the law there? Section 31 subparagraph 9 of the Notary's Ordinance. Either you should know the executant means seller or the witness. Now, what is the practical side happening? Who is coming to us? The person who is coming to us to do the transaction, not the seller. No buyer will go and give it to seller's lawyer to do the deed. No, the seller. So when the seller comes, seller also doesn't know the notary. Buyer also doesn't know the seller at all. So he comes, and just to do a transaction and make a quick buck, what do? We also don't know who this seller is. What do? We get either our office clerk or a peon or a junior or a driver to sign as a witness. And what do we say in the attestation? Vendor or the executor not known to me, said to be known to the witnesses. If something goes wrong, your poor innocent either clerk or peon or driver will go to jail, and you say, why? You say, I don't know him at all. Now, similar thing happened. A notary who has completed 50 years in the bar, who has even written, very well reputed notary, and who has written books in regard to conveyancing, executed a deed. As I just said a little while ago, he got his driver as well as his son, who is a lawyer, to sign as witnesses. Deed was challenged, and finally he was indicted. Not even 6 months he lasted, he died. A very well-known notary. So that is the very reason now, in terms of the new law, we have brought a section 31, subparagraph 9 amendment. What is the amendment? You should know one of the two. Who is the one? Either seller or the buyer. Obviously you know one of them. There is no question at all. Without knowing the buyer won't come to you. So next one, witnesses. And we have gone a step further to protect further. and to say, even if you, of course, you should know, and also we also can say, I peruse the driving license, identity card or passport, and verify his identity. So we have now taken, as I said at the beginning, we had taken a lot of steps to safeguard the notaries as well as not to protect the cookish notaries who are doing wrong and to take steps against them. So that's why stringent procedures we have followed, and also we have relaxed certain laws to protect the notaries are there. So coming back to this question of notaries, this attestation, you have to follow the attestation very clearly. In the attestation, you should say basically, number one, who is known to you, whether it's a seller or the buyer. Then the second thing, who signature kept, whether it's left thumb impression or right thumb impression. Then the next one is in regard to affixing the photograph, you have to certify and say this is so and so. Then next is how the consideration of pay, whether it's by cash, whether it's by check or there. There are instances where I come across, well-known even notaries are there, post-dated checks. You execute a deed today, 13th of February. You can't put December 2025 checks. These are not selling items in PETA. These are noble profession. We are doing deeds, executing. So there are instances where they put post-dated checks invalid, because that's not a property sold or purchased for a valuable consideration. Therefore, those dates are there. So the attestation matter, you have to be very careful. Those are the things what I would say. And also finally, most crucial thing, you also have to specifically say when you have, whether there is any thing has been erased, written over or done, anything you have to say. There again, I can tell you an interesting story there. A deed, some matter came up before me there. A deed was executed. And during when a marriage was in subsistence, husband gifted the property to the wife, absolute, irrevocable, and she had the original deed with her there. Then finally, when the divorce papers are served, I found the deed has been cancelled, and also action has been filed to, not action, the relief has been asked in the divorce claim to eject her. Then this lady brought the deed to me and I told, Madam, can I see the document? I saw the document. Perfect. There is no eraser, nothing at all written over, nothing there. It's perfect. Then I applied for a certified copy from the duplicate and I found it has been altered. So you could see when a document is annexed and attested, original, duplicate, protocol, all have to be there. The case, he could not succeed at all, action got, he failed the action, he couldn't succeed. But the fact is, look at the fraudulent thing what that over there. The lady had the original deed. No correction, no interpolation, no erasing, nothing at all. But the duplicate with so many things and say I further certify attest, I did this. So if they have done all those things, it should have been done to the original, not to the copy. So I think I mainly dealt with you the problem that you face. Now I think, strictly speaking, now only I am going to start with the lecture proper, because I am sure if I have gone through simply explaining the sections are there, because most of you are not here to you are not listening to the lecture mainly to find out about the amendment. Your main task is to how to resolve problems. I hope that the question that I discussed would have been useful. Now let me get back to the main thing. I'll run through quickly because of the time issue. Now I'm going to deal with the Notaries Amendment Act. Basically the salient features. The first salient feature introduced by the new Notaries Amendment Act is, in terms of section 31 subparagraph B, it is mandatory to do a search. As I said a little while ago, you have to do a search. It is mandatory. In addition to the search, it is also mandatory to obtain a certified extract from the folio, the land registry, and also you have to insert the folio as well as the volume in the thing there. So that is the very reason I said at the beginning itself, it is a mandatory provision. So if any notary has not inserted the folio and the volume, that shows is executing that deed violating the provisions of the deed. So you have to do that. Prior to this law came into operation, the situation was different. There was a provision where you can search dispensary. Now, section 31, subparagraph B, there was a provision. We have repeat. Why? 99.99 fraudulent deeds. What they do is, they get the client's signature and say, search dispensary. Imagine a person who sells all hard-earned money and purchasing a property, who will go and tell a notary, don't check the entries and just write a deed. No. So most of these fraudulent deeds, the defense of the notary, look at the document, here the client has signed. So therefore, we have now removed that particular thing. No more search dispensary. You have to do a search. It is mandatory. Not only you have to do a search there. Now, there are instances, some of these notaries are creating a problem and saying, look, in regard to leases, why should we do a search? You have to. Why? Say for example, the lease that you are entering into respect of a particular premises may be subject to a mortgage. So if you execute a deed of lease subject to a mortgage, and if something goes wrong, that particular lease is subject to the mortgage, you will get thrown out of the premises. So therefore, whether it's a lease or gift or transfer or any document, search is a must. Then second salient feature is, in terms of section 31, 15A, 1A of the Notaries Amendment Act, in addition to the signature, thumb impression, it has to be put, either it is beside or above the signature, and to all three, original, duplicate and protocol. And normally, as I said previously, as a matter of practice, we use the left thumb impression, but it says either way, it can be a left or right, you can. Then there are three kinds of the third salient feature. There are three kinds of deeds in terms of section 31, subparagraph B, subparagraph 3, in regard to three kinds of instrument: deed of transfer, deed of gift, deed of exchange, last will. You have to affix the photograph. It is mandatory. As I said previously, those photographs were initially affixed to the original. Now it is affixed to the protocol, mainly to safeguard the notary. That has to be done. It has to be affixed to them. Then next is in regard to the four instruments that I said: last will, deed of transfer, deed of exchange, and the deed of gift. Then in regard to the affixing the seal photo, of course it's not mandatory. I read it in detail. Basically, when you put the photograph, not like a passport one, you have to say, you need not do exactly to cover the face or anything at all. You have to say, this is the photograph of so and so. Then you have to put the date and also put your seal. Now that is in regard to the execution of deed. I'll repeat it again. First and foremost thing, any notary should do a search in the land registry. Why do they do a search in the land registry? To ascertain encumbrance. What are the encumbrance? It could be a caveat. It could be a lispender. It could be a seizure notice. It could be a priority notice. It could be a mortgage bond. It could be a lease agreement. Now say for example, a caveat is there. When a caveat is there, what is the meaning of a caveat? We call a caveat emptor. අපි සිංහලෙන් කියනවා ගැනුම්කර ප්‍රවේශම් වැති විය යුතුයි. එහෙම නැත්නම් buyer must be aware. What do you mean by that? Somebody has put a documentation to the land to say, if there is any transaction pertaining to this property, please notify me. There are instances, especially young notaries saying, look, this caveat, person who has put a caveat has no interest in the land, and therefore don't worry, let the transaction go through, subsequently we can resolve. Don't do that. Why? In case if a person has a valid interest and put a caveat, and if a transaction go through, in terms of section 32, subparagraph 5 of the registration documents ordinance, you will be liable for damages. Then second one, lis pendens. It's a Latin term once again. Action pending. When a case is pending, if you do execute a deed and by the court order, if that deed nullifies or something wrong, you will be responsible, your license will get cancelled. Seizure notice. What do you mean by seizure notice? By a court order where the property has been seized. The property has been seized, seizure notice there. So if there is a seizure notice, notwithstanding the fact that there is a seizure notice, if you do execute a deed, two things can happen. A, the deed will be a nullity or null and void. Number two, you can be dealt for contempt of court. Why? there is a specific court order not to execute any deed, and property seize property, you execute a document. Then next one, priority notice. What do you mean by priority notice? Especially these priority notices are put by the bank, notifying the party, maybe 6 weeks, maybe 4 weeks, saying that we intend to purchase this property, or we intend to give a bank facility there. So in such event, until that priority notice period is over, you should not execute any deed. The next one is mortgage bonds. Now, come back to question of mortgage bond. It can be either lending institution or a bank mortgage or a private mortgage. Now, there are enough instances where we come across, there are mortgages which are about 20-25 years old. What you should do is, especially when a person is outside living country, not in Sri Lanka, and he has sent a power of attorney to Sri Lanka, appoint a Sri Lankan person as a power of attorney holder, in such event, what he should do, he must get an affidavit from the, you have to get an affidavit, the notary must get an affidavit from the Sri Lankan person to safeguard yourself, to say that I am the duly appointed power of attorney holder. I hereby authorize the so and so, who is the holder of identity card number such and such, who is the intended purchaser, is a Sri Lankan citizen, he is not a citizen of another country, and you have to safeguard, because otherwise you are committing an offense. As a notary, you are committing an offense, and therefore be cautious when the people send power of attorney from bringing power of attorney from abroad. A local person is executing signing the deed for and on behalf of the respective buyer. When a Sri Lankan Land Alienation Act specifically says giving exemptions are there, if you are a dual citizen, those things are different. And here very specifically when it prohibits, if you are a foreign national, being a Sri Lankan, now foreign, all are same. So if you are a foreign national, you are no longer a Sri Lankan, you can't buy a property, and you can't deviate the law by keeping and misusing the identity card. So therefore you have to get an affidavit from the respective attorney to the effect to say that particular person is a Sri Lankan, he has not surrendered his citizenship, he is a holder of power of attorney, identity card number, and also power of attorney genuine, still in full. Then the other issue is in regard to when you are doing transaction of power of attorney, you have to be cautious. There are instances where I come across, some of the power of attorney people are granting fraudulent. Some of them people are even dead, and notaries are dead and gone, not alive. So therefore, now with today globalization, everything is online available. If a power of attorney is given, say for example from Canada, or maybe London, maybe Australia, you have your colleagues, you have your people there. Verify the veracity of that power of attorney. You know who executed. If it's a Sri Lankan person, check and see. Sometimes there are instances where I got to know where a UK power of attorney came. I knew that very well that person has been disenrolled. So when I saw the name, I said, no, this power of attorney is a fraudulent one, because this person is no longer been disbarred. So likewise, you have to check. That's one. Second thing is, tell your client, or you get the details of the principal person who is giving the power of attorney, say that I am the intended purchaser, get an email to your address. At least then you know there is a direct transaction between the person, or at least your client who is the intended purchaser. Ask him to send an email to him and say, look, I am the owner, I intend to sell, this is my, then you know the person is existing there. So you have to be very cautious, because there are a lot of fraudulent transactions are taking place based on powers of attorney. So you have to be careful. Now the next one is when a limited liability company is selling a property. What have you got to do? When a seller is a limited liability company, first and foremost thing that you have to do is to ascertain the memorandum and articles of association, who is authorized to sign the deed of transfer on behalf of the company. Now take for example a company is a legal persona, we say. It can be, according to the article, 2 directors, or a director and a company secretary, or an authorized person. So you have to find out who is authorized to sign in terms of the law. There can be one director company. So you have to check and see. Then, for example, as per article, it could say company seal be affixed only in the presence of 2 directors, director or company secretary, or authorized person. Addition to that, you also must obtain this document, certificate of incorporation, Form 1, Form 15 annual return, Form 20, as well as the board resolution. So those are the most important things. First and foremost, check the memorandum and article. There will be a special column to say seal. It will say seal of the company should not be affixed unless in the presence of two directors, director and secretary, or authorized person. That's one. Then addition to that, these documents, certificate of incorporation, form 1, and then form 15 annual return, or form 20 director's detail, and the board resolution. You have to have a board resolution if you are selling a property, who will be authorized to sign for and on behalf of the company for the deed of transfer. So most of these land sales and other places are there. Instead of board directors, what they do is, because so many documents have to be signed, so many thumb impressions have to be put, so they appoint a person who is an authorized person to sign the document there. Then the next is, especially when a company is selling a property, more than 50% of the company value. Say for example, if a property is worth 100 million, the company is worth 100 million, and they are selling a property which is worth by the company for 75 million, you have to get the, in terms of section 185 of the Companies Act, you have to get the shareholders resolution. Why? It's affecting the rights of the shareholder. So number one, check the memorandum and article. Number two, get all the Form 1, Form 15, Form 20 and Certificate of Incorporation. Then board resolution, the board director, and also you get the, if it's a major transaction, get in terms of section 185 of the Companies Act, you have to get the shareholders resolution. Similarly, when a company is buying a property too, you have to follow the same procedure, do that. But specifically, you have to see in the act whether that particular memorandum article permit for the acquisition of lands. So that is very important to see. I think as time constraint, I'll quickly run through with the registration of documents ordinance. Powers of attorney ordinance. Yeah. Now, Powers of Attorney Amendment Act. The salient features of the Power of Attorney Amendment Act as follows. As per Section 3, subparagraph 1A of the Amendment of Act, registration of power of attorney has been mandatory, as a registration of power of attorney was optional. So prior to this law came into operation, it was optional. If the party feels they can register power of attorney, it is not mandatory. Now it has been made mandatory. Then the second one, in terms of Section 3, subparagraph 1B of the Amendment Act, the power of attorney executed in Sri Lanka same to be tendered for registration within a period of 1 month. If it's a foreign power of attorney, within a period of 3 months. So back again, time limit has put for the power of attorney. 1, registration is mandatory. Number 2, if it's a local power of attorney, Sri Lanka power of attorney, then 1 month. If it's a foreign power of attorney, 3 months. The next thing, who can sign the power of attorney? In front of whom? As per Section 2, subparagraph 1B of the Amendment Act, when a power of attorney is executed outside Sri Lanka, same to be signed in front of a ambassador, High Commissioner, diplomatic officer, consul office, or a person authorized to sign. When you say a person authorized to sign, in terms of that country law, it can be a notary public, it can be an attorney at law, it can whoever the person, or it can be justice of peace, whatever that country law recognizes. Then as I said earlier, it was mandatory in regard to a foreign powers of attorney earlier law. 2 witnesses have to be there. Now it's not mandatory. That particular provision has been now removed. Next one, Section 3, subparagraph 3 of the Amendment Act. When a power of attorney is executed in Sri Lanka, the power of attorney should accompany with a copy of the by page of the principal's passport, which has been signed by the principal himself, stating that this is the by page and in fact a copy of his own passport. So when a power of attorney is executed, the principal must take a photocopy of his power of attorney. He has to certify his bio page and say this is this particular photograph, or the person who is affixing it myself. So you have to have a photocopy affixed by the person concerned. Then as per Section 3, subparagraph 2A, B and C of the Amendment Act, when a transaction falls within the scope of the Prevention of Frauds Ordinance, in such event, it mandated to set out the description of the land. So, when even it's a power of attorney, it is in regard to a sale of a property, specifically you have to set out the metes and bounds, where volume folio, where it's registered, all that is mandatory. That's very important. Then earlier law was we had irrevocable powers of attorney. So no longer irrevocable power of attorneys are valid, and only people who can have irrevocable power of attorney is state institution. And we had that was I must explain and say these irrevocable powers of attorney has been not the banks, most of the unauthorized lending institution who gives money, they get this irrevocable power of attorney, lend money to large sums of money. One instance where I'm personally aware of it, the property worth in the, I can't give in the vicinity of Colombo, it's worth about 10 billion, not small amount of money. So they particular company lend about 1/20th of the amount, like 500 million, to pay within a period of 6 months, and got an irrevocable power of attorney. Money could not be paid, made use of the irrevocable power of attorney, property sold. So that is the very reason banks are not. We are concerned about the bank situation there. So there are some amendments coming in regard to the bank, not the banks. I'm talking about lending institutions who are not registered with the central bank there, they misuse. So that is the very reason we say no, irrevocable powers of attorney granted only to the state institution, not to other person. And also now power of attorney can be easily cancelled, and therefore validity only for a period of 5 years are there. Then the other issue is back again, transitional provision, I'll come back. But as I said earlier, in terms of section 8B, notwithstanding the fact whether it's 5 years so irrevocable, if that power of attorney is given prior to 22nd of October 2022, notwithstanding this fact, irrespectively, in a retrospective effect, those powers of attorneys are valid. So you need not be worried in regard to the bank raises the issue. Look, we have so many thousands and thousands powers of attorney given to the bank. What is our answer? Is very simple. 8.2 covers. Transitional provisions we have covered and say, if you have got a power of attorney, it can be irrevocable, it can be for no period of time, and you will be valid, nothing to worry about. Then, in regard to the cancellation of power of attorney also, we have made the procedure very simple now. Earlier, the law is when you say power of attorney given, absolutely cumbersome. Absolutely cumbersome. Why do I say? A, you have to publish in the newspaper. You have to put it in the gazette notification. Long drawn process. Now is completely different. As per section 4, subparagraph 1 of the Amendment Act, when a principal of any power of attorney or the power of attorney holder wishes to revoke the power of attorney, such principal or a power of attorney holder should, number 1, notify the other side the intention to revoke power of attorney, execute a notarial document declaring his intention to revoke the power of attorney, specifically expressing his intention that the power of attorney holder is not to act under the said power of attorney, submit such revocation of power of attorney for registration under the relevant extract and cross-reference there. So what have you got to do? Very simple. You give a power of attorney today, and you find that your power of attorney holder is going to play out. Simply, that's one. Second thing is other way, where you get a power of attorney. You feel is a headache to act for somebody is there. He said, I'm not interested. So all what you have to do is in terms of clause 4, subparagraph 1A, but first thing, notify the other side the intention. What is the intention? I do not intend to continue I do not intend for you to be a power of attorney any longer. I am cancelling it. Number 1. Number 2, you execute a notarial document, cancel it. In the notarial document, all what you have to say is cancellation of power of attorney. In the body you say, under and by virtue of power of attorney, wherein number such and such, so and so was appointed as an attorney, and the said power of attorney is registered under volume and folio such and such, and I have given notice of revocation of the power of attorney to him, annex that document, and say, I do not hereby authorize, I do not hereby intend to continue to do any act done by so and so will be not valid. You see, now very often when somebody is leaving the job with a massive photograph, like a half a page, so and so is no longer in our institution, we are not responsible for any act done. Similarly, you do the documentation here, say that. So you send that to the land registrar general of it. Of course, you have to put the correct volume and the folio. Where it is registered previously, this will go and get registered. So I repeat it again. In terms of section 4, subparagraph 1 of the Amendment Act, if the principal or the attorney both can do, what have you got to do? Number one, notify the other party the intention to revoke the power of attorney. Number one. Number two, do a notarial document declaring the intention to revoke, and need not give one but reason, nothing. You have arbitrarily you can revoke, expressing his intention and also say where is registered. Then you have to tender that for the registration, and in the cross-reference say where it is registered. Same folio it will be registered with a cross-reference like we put in the land registry called a remarks column, cancel. So when you go to do a transaction, when you check from the Registrar General, you know, look, yes, this man has power of attorney is valid, not valid, now it's cancelled. Don't do that. Then the next issue is very important. This is Section 4, subparagraph 2A of the Amendment Act. If a principal wishes to revoke the power of attorney with immediate effect, until such documents are prepared, either the principal or his attorney could notify the intention to revoke the power of attorney to Registrar General by notice in duplicate. Upon the receipt of such notice, the Registrar General shall make an endorsement of the cancellation of relevant voluble, having given the notice of such intention. Is that. So this is another crucial thing. That is to say, you revoke, now say for example, you live in a foreign country, we'll say Canada. You are in Canada, you give a power of attorney to someone. You know very well that your attorney is going to play out and you are not happy. Now you can't come. You can't appoint another power of attorney holder. What have you got to do? Couple of things you can do. Either by email or any other means through a lawyer here, you can send a letter to the Registrar General notifying. I write, say for example, lawyer writing. Lawyer has every right to write. I write on the instruction of my client so and so. My client appointed so and so as a power of attorney holder to act whatever the purpose, and my client doesn't wish him to continue as a power of attorney holder. In terms of Section 4, subparagraph 1, notice has been given to him, say that he should not act as a power of attorney holder, and therefore kindly request you to enter in your books that he is no longer wishes to act there. So no sooner letter goes like this, it will be in the remarks column as a reference there. Take for example, similarly, like RMB, there is a vehicle registration there. So husband buy a property vehicle in the name of the wife. Now there is a family dispute. So husband writes and says, although the vehicle is in my name, you paid the money, and therefore in the event of any papers transferring this property document come, please don't accept. Similar stay here. Yeah, you write a letter through a lawyer or directly, either from solicitor in whatever part of the world you are there, you can send it, or Sri Lankan person can do. But then that will be recorded in a remark column and say, yes, such and such a document has come, it will be registered. So during that period of time, if there is any transaction comes in, there you can go and see, look, whether the power of attorney is valid. No, there is a remark column, someone has objected, therefore we should not act on this power of attorney. So you can see the advantage that we have given now when a person is there. But having done that, if a person is living abroad, he can't just keep quiet and sleep over with his rights. Within a period of 3 months, he has to take steps. Having sent a notification to the Registrar General Office saying that I intend to revoke proxy, I intend to cancel the power of attorney, don't act on his power of attorney. Having said that, you can't thereafter turn back and keep quiet for a period of 3 months. You have to act fast. If you don't act fast, upon the completion of the 3rd month, the validity of that notice will be out. Back again, the power of attorney will be in reinforced, and therefore steps should be taken within a period of 3 months from the date of, I'll just read it again, the very crucial section. As per Section 4.2a of the Amendment of Act, if a principal wishes to revoke the power of attorney with immediate effect, until such documents are prepared, either by the principal or his attorney. I am repeating this, either by the principal or attorney, because we are given the option, even the attorney, to cancel. If the attorney doesn't wish to act as an attorney for the principal, he first write to the principal and say, look, I wish to draw your attention to the power of attorney granted by you to me, act for such and such a thing. please note, I do not intend to continue as your power of attorney holder. I intend to revoke. He can revoke. So I read it again. As per section 4, subparagraph 2A of the Amendment Act, if a principal wishes to revoke the power of attorney with immediate effect until such documents are prepared, either the principal or his attorney could notify the intention to revoke the power of attorney to Registrar General by notice in duplicate. Upon the receipt of such notice, the Registrar General shall make an endorsement of such cancellation in the relevant volume folio, having given notice of the intention of cancellation. If same not cancelled within 3 months, such notice will automatically become invalid. So this is a very crucial section. As I said initially, a power of attorney is no longer cumbersome. Like earlier, putting in the newspapers, gazette notification, all that rigmarole you need not go through. Very simple process now. Section 4, subparagraph 1 of the Amendment Act, it says, when a principal of any power of attorney holder or the power of attorney holder wishes to revoke the power of attorney, principal or power of attorney holder should A. notify the other party. Number 1. Having notified, what they should do, you have to execute a document declaring his intention to revoke the power of attorney, specially expressing his intention that the power of attorney holder is not to act under the said power of attorney. You need not set out any misunderstanding, he played me out. None of these things are needed. All but you have to set out in a cancellation of power of attorney, very simple. By power of attorney number such and such, dated such and such, attested by so and so notary public, I appointed so and so to act for the following. As I do not wish for him to continue as my attorney by letter dated or by such and such or by through a lawyer, whatever there, I have notified him that he should not continue to be my power of attorney holder with immediate effect. A copy of that letter is enclosed herewith, and then say that power of attorney is no longer valid, in force, and send for the registration. When you send it for registration, important thing, crucial thing, and a mandatory thing is to set out exact volume folio where the original power of attorney is registered. Otherwise, it will go to a stray folio, or it may not even get registered properly. So that is important to do. So once that is done there. So similarly, same stand can be taken by the attorney. Attorney feels this man appointed me, say for example, a court case. It's a nuisance. He has to go to court, give evidence, and go through massive harassment. He says, no, I'm no longer interested. Very simple. Same process he follows. He writes a letter or notify the principal, either if he is abroad, either by email or whatever communication, and say, I'm no longer willing to act. And he also could execute a similar document, provided he must have the prior registration, volume and folio to insert to the new power of attorney, and to say cancellation, new power of attorney, and then submit for registration, then it will be cancelled. Similarly, the other issue is, if somebody want to do something very quickly, as I said, person is abroad, unable to come, how can he cancel immediately? The process is very simple. Same procedure to be followed to notify. It can be done by the principal, it can be done by the attorney. So notify the other side and say, I refer into the power of attorney, number, date, who has executed, caption is that. With reference to the power of attorney granted to me by you, or the other way, vice versa, I hereby inform you, I am no longer willing to act as a power of attorney holder. Or other way, principal says, I do not you to continue as a power of attorney holder, and then write a letter to the Registrar General, either through a solicitor in that time, wherever you are, or a person in Sri Lanka. He says, assume a person in Sri Lanka doing, he can say, I write on the instruction of my client so and so, and I have been instructed by my client to state that my client has given a power of attorney to so and so, attested by so and so, registered under volume such and such, and it's no longer valid, and notice of intention has been given, and steps will be taken within a period of 3 months to do the cancellation and send it there. Then automatically it will be cancelled. And why I am saying all this, it is very crucial. It is very, very crucial for you to follow up to see whether the power of attorney is duly registered. And similarly, the last one now, when in regard to this, banks raise this issue very often there, whether the earlier powers of attorneys are valid or not. I'll repeat it again. Whatever the power of attorney given prior to Act number 31 of 2022, namely before 22nd of October 2022, are valid and in force. I'll read the section. As per section 8, subparagraph B of the Amendment Act, where a power of attorney has been duly registered in terms of the provisions of section 3, which has not been revoked prior to this Amendment Act, same shall continue to be valid until revoked and cancelled under section 4 of this Act. I think it's time constrained, so I think I have to wind up now. Thank you for your kind patience.
Thank you, sir. If any questions? Sir, there's a question.
Sure.
If the purchaser and the POA of a purchaser are abroad, how can transfer deed be executed?
Yeah, both ways it can be done. One is as stated in the earlier one, you can, if a buyer as well as seller both are abroad, either both could give a power of attorney to two different people. Seller by one person, buyer by another person can be done. In terms of the amendment to the Prevention of Fraud Act, where even by a letter of authority could receive, but you can't sell. So simple answer is both parties could give powers of attorney to two respective people, then it can be executed. Or if it's a buyer is in a difficulty, buyer can give a documentation called authority set out in the Prevention of Frauds Ordinance to sign the deed.
One more question. To what kind of instruments thumb impression is mandatory? Deed of declaration and rectification and connections.
No, thumb impression. You're referring to thumb impression. Are they talking about thumb impression?
Yes, sir.
No, in regard to thumb impression, as I said earlier, thumb impression we suggested only to deed of transfer, gift, exchange and wills only, but Act is in such a way it has not been altered. In regard to almost every instrument, now the thumb impression is needed. It's not specified for any document, all documents.
And
Sir, may I ask a question?
Most certainly.
yeah.
Yes, thank you, sir. May I know, sir, if a citizen, Sri Lankan citizen who has gone abroad and obtained foreign citizenship, that person wishes to sell a land through an power of attorney, any safeguards the notary and the attorney holder should do in Sri Lanka?
Yeah, that exactly I told you a little while ago. You see, if a person is selling a property, the most important thing is that if you happen to be the purchaser's lawyer, first and foremost, we have to verify the genuinity of the power of attorney. So the fact is that because there are instances, as I said earlier, the notaries who are executing powers of attorney are no longer in existence. Some are dead and gone, and some are disbarred. So therefore, as today with the global situation, you can verify whether that particular power of attorney is valid. If it's a Sri Lankan person, you can check with one other person there. Then the other issue is, if you are acting for a buyer, get the buyer to directly seller to communicate with you by email or any other documentation. Then you know there is an existing person who is doing it. So you can have a direct communication. And for him to say that, yes, I am the buyer, I am the seller, I am the holder of whatever the passport or identity, whatever they are, I intend to sell it. So then there is a direct communication between the two parties. And as I said earlier, in regard to sale consideration, ensure the power of attorney allows to receive the money in that person's name. Wordings are important.
Thank you very much, sir.
Questions are following many. Can a deed of gift executed to the foreign national?
No, question is foreign national mean that particular foreign national whom we are referring should be a person who falls in terms of the Land Alienation Act, kith and king. If that person falls into the category of kith and king, now say for example, mother or father wishes to give up a gift of property to a child, if that child is a foreign national, not a Sri Lankan, he can receive it as long as that person fall within the definition of kith and king.
May I be allowed to ask a question?
Most certainly.
Yeah, please.
Yeah, so my name is Anita. Just want to check now. I think you mentioned in a transfer deed, you said the buyer has the right to retain his lawyer and do the necessary due diligence before he buys it.
Yeah.
But in the recent past, what I've noticed is that in most of these apartments, the developer insists the buyer to go ahead and get the done through their internal legal. And they also have clauses in the S&P where it very clearly says that the title have been checked and that you're satisfied and no objection should be raised later on. And at the bottom it says your deed has to be executed through the internal lawyer. If not, they impose a charge which I think is highly unreasonable charges they impose if you go to an external lawyer. What is the position on this, sir?
Yeah, I fully endorse the things what you said to, because I too have faced this problem very often. You see, what happens is when you do the sale and purchase agreement, they put that condition and to say that look, it has to be done by their lawyer, no one else, number one. And number two, they don't even indemnify and absorb, not even warrant and defend the title. They say that. So I think through, in fact, I have brought this to the several complaints have come again. I don't want to mention the names of the so-called developers. There are quite a lot of developers who are doing this, and also certain clauses not in our known law. There are certain clauses and also internal, they have their management agreement clauses. So I have made, I told the Secretary of the Bar Association also, I think Bar Association should make representation to the relevant authorities, and we have to inform this kind of thing should not be permitted, and also it's a detrimental to the buyers and also violating the laws of the country. We have to take steps, definitely. Good that you raised that issue.
Thank you, sir.
We have questions, and Notary's ordinance requires to verify the identifier of execution and witness by inspecting NIC, driving license, passport. In practice, what if the executant says that their NIC is lost and have applied for the new one, and he doesn't have the driving license or passport? In such case, can be allowed to execute the deed?
You see, in terms of section 31, subparagraph 9 of the Notary's ordinance, before you execute a deed, you should know one person, namely, either they should know the seller, buyer, or the witnesses. I'm sure at least one of the parties he should know. And also, now come back to the question of all the parties can't say they have lost, no. So at least he should know one. Either he should know. Obviously, if a buyer is coming to you to do a deed, obviously you should know the buyer. If you don't know the buyer, at least the witnesses should know the buyer. Even if you don't know the witnesses, we have specified here in terms of the Notary's ordinance, I have checked the identity at the inspection of the witnesses and satisfied. So one of the three he should know. Either he should know the seller, or he should know the buyer, or he should know the witnesses. If nothing is available, at least he must get a documentation from the Grama Sevaka to say he is a person who living in there. Some documentation to authenticate it, identity has to be there.
In case of the post-dated checks have been given by the vendee to vendor before us, in the attestation part, are we supposed to state that the consideration was not passed before us?
As I said earlier, the question of post-dated checks are not part of our transaction at all. This is not selling items or buying items in Peta market. So this is doing a transaction. So if any money, if a client said that paid previously, all you have to say is the consideration set out in the deed has been not paid in my person, and if that person say, if he want to say the money has paid prior to the execution, that you can say it has been as per the purchaser, it has been paid prior to the execution. You should not take a responsibility, and you should, because section 31 subparagraph 20G of the Notary's ordinance specifically says how the transaction took place has to be clearly set out. So you can't, post-dated checks is completely prohibited in law. Addition to the fact, I'll read the section 31 subparagraph. Whether any money was paid or not in his presence as consideration, part of the consideration of the deed, if paid, actual amount, local currency or a bank draft, he must set out the transaction. no way post-dated check can be accepted, and also the deed will be a nullity. So it's not for a valuable consideration.
Sir, there are so many questions, so what shall I will email you.
Yeah, you can.
Okay, if you are willing, I can ask.
I'm willing, no problem at all. You can. If you have time, you can ask me.
Okay. Can a deed of gift be executed without acceptance clauses by the donee, who is supposed to be a minor, allowing him to accept the gift once he attains the age of majority?
No, you can't. Minor you can't. That is where the law is very clearly states, and even that circular I read out, on behalf of a minor, either father or mother or a legal guardian should accept. You can't do a deed today, waiting till 18 years to confirm it. You can't do that.
So continue from the previous question. If the donor transfers the property to the third party without noticing a donee, and before acceptance by the donee will be the third party purchaser get the good and clear title?
No, as I said earlier, the deed of gift is a thing called it's a contract, offer and acceptance. Somebody is offering a land, other person is buying. So if that particular person offering, if the other side is not accepting it, the deed of gift won't be fulfilled. All what the person can do is he is gifting. If there is no deed of confirmation subsequently, there is no valid gift.
What are the taxes the seller has to pay? Capital gains tax? Can you explain this?
Yeah, so capital gain tax, the law is when you sell a property, say for example now in 2025 you are selling a property, the capital gain tax is actually it's not been strictly imposed, it's a voluntary declaration, generally it happens. So capital gain taxes, they look at the value in 2017 and as at today what has gained. Now say for example if a property value was say 10 million and today you are selling it for 11 million, you pay the difference of 1 million 10%.
I think you catch this question, this thing lecture, but I will ask you, what is the restriction to purchase land by foreigners? What is the mode to remit funds?
No, foreigners can't buy any land. There is no question at all. There is a direct restriction. But in terms of the Land Alienation Act, foreigners can buy any condominium unit. But for them to buy, money should come through the proper channel, not through money laundry or undial or any other way. It should come through a proper channel. Otherwise, you can't buy. And foreigners, simple answer to your question is, no foreigner can purchase a property except for a condominium unit. Of any floor he can buy, provided if the money has come from abroad.
Excuse me, sir, may I be permitted to ask a question?
Sure.
Yeah, sure, go ahead.
Sir, in terms of the new amendment to the powers of attorney ordinance, foreign power of attorney can be executed before a person who is authorized in terms of that such foreign country. Is there any formal mechanism to ascertain who are the authorized in terms of designation who are authorized to attest such execution?
No, easier way to find out it from the respective High Commission in Sri Lanka, because generally, say for example, in certain countries, there was an action, in fact it was a challenge, even in England I think, even notaries can do. So depending on country to country, the recognition. So I think the best place to verify is the respective consul office or the High Commission.
Thank you, sir.
If I may ask a question.
Certainly.
Yeah.
With regards to dual citizenship and land transactions, now, as you mentioned, sir, what happens when Sri Lankans obtain foreign citizenship, let's say, for example, India or New Zealand, they automatically lose their Sri Lankan citizenship. So, in effect, those type of people, they're supposed to get the NIC also new. So, what happens is, some of them, in their passport, they don't even have the endorsement to say that they're a foreign, they're a dual citizen, nor have they obtained the new NIC. And sometimes I've come across one where they've issued the new passport, they've renewed the passport without the NIC being renewed properly. So in those circumstances, have you all, is there like a committee looking at this? Because people are kind of confused as to the situation with regards to the Citizenship Act's sub-provisions of getting a new NIC. Because some of them don't understand that their previous NIC is not valid now after their dual citizenship was obtained with the Sri Lankan original citizenship going away. When the new one is formed. So are you all looking at that, sir? Whether to
no. The question is, you see, if you look at the Land Alienation Act, the people who are exempted category, even a dual citizens could purchase. There is no issue.
Yeah.
So the question is, irrespective of the fact whether they have identity or not, that question doesn't arise. They have a dual citizenship.
Okay, so even if they have lost their Sri Lankan citizenship originally and now they have the dual, the requirement of getting the new NIC, it doesn't come into play?
It is really not mandatory. There is no question.
Okay.
That is basically whatever Sri Lankan purposes for them to use within the territory is useful, not otherwise.
Okay, thank you, sir.
Can I ask you a question, sir?
Most certainly.
Yes.
Sir, you were referring to a circular, and in terms of that circular, power of attorney and a mortgage bond can be executed in a form of a default where only one party sign. Whereas, if I am not mistaken, in terms of the act, it has to be in the form of an indenture where two parties sign. So, sir, my question for you is, how can a circular overrides legislative enactment, sir?
No, it is not a circular. It is not a circular as such. The question is, you see, what happened was that initially when the law came into operation of Operation 31 of 2022, there was a interpretation. There is an interpretation word called, there is an interpretation in regard to a word executed. Then executed means in regard to deed of transfer, transferor and transferee. In relation to all other instrument, it says parties to such instrument. So the question of interpretation created a lot of issues. I'll read the single one, you will understand better if I say. Yeah. ලියා අත්සන් කරන්න යනුවෙන් විකිණීමේ ඔප්පුවක් සම්බන්ධයෙන් වෙන්නේ විකුණුම් කරුත් සහ ගැනුම් කරු අනිකුත් ඔප්පු සම්බන්ධව සාධන පත්‍රයන් දෙන සාධන පත්‍රයේ සියලුම පාර්ශ්වකරුවන්. So when you say සියලුම පාර්ශ්වකරුවන්, the question now then subsequently 43 was repealed. So 43 was repealed, the old law came into operation. So the fact is, because of the word සියලුම සාධන පත්‍රයේ පාර්ශ්වකරුවන්, so then, if you look at the power of attorney, the power of attorney ordinance act says only the executor is the principal. But when you use the word all parties, people said you have to sign the principal as well as the attorney sign. Now, say if a person is in UK, if he is giving a power of attorney to a person in Sri Lanka, how can you do that? You can't do. So it's not a question of overriding the circular. Circular is only clarifying the lacuna in the law and say because of the contradictions in the two acts, the circular has only clarified, not override anything.
Yes, sir. Thank you, sir.
Sanita?
I'm Nazrin from Trincomalee.
Yes.
Sir, for the deed of gift condition, it is a irrevocable deed.
Yeah.
Then after 2 or 1 year, the both party agree to revoke the deed and they can execute a deed for the revocation of deed and cancel that gift.
No, in terms of revocation of gift number 5, there is no, assume for a moment, if there are 3 ways of you can do a deed, no, either by subject to life interest or subject to revocation right or irrevocable. If there is a right reserved to revoke even without assigning other reason, you can revoke. But if it is irrevocable deed of gift, if both parties agree even, there is no revocation as such. All what you have to do is you have to transfer to the other person. You can't amicably revoke.
Thank you, sir.
Sir, one more question. If you're working out on a transfer based on a power of attorney,
Yeah.
and if the principal is very old and not in a proper state of mind, but of course the power is not cancelled. What could be the situation?
Say it again.
The principle of the power
Yeah.
is still living, but not in a good state of mind because due to age.
Okay.
But the power of attorney is yet valid.
All right.
So if you are selling, if the principal is selling a land via the holder, what would be the situation?
No, you are referring to the person who is power of attorney holder is concerned.
Yes, the attorney, not the principal. The principal is very old.
So, is the person is in Sri Lanka?
In Sri Lanka living.
Yeah. So,
But very old, not in a proper sound mind. I
so has he given a power of attorney to anybody?
Yes. Yes.
Right. So now it's a wish of the person. No, if he want to wish, he can cancel the power of attorney and give it to somebody.
Yeah, but do you have to go to the extent of checking whether that person is yet in a position where he is now? You said to try and contact the.
No. But if a person is in foreign country, you have to definitely not that you have to, for the sake of precaution, you have to check that because you don't know now the real position. If a man is dead and gone, still they can make use of the power of attorney.
If the person is living, sir, if the person is living but not in a proper sound mind,
No, but then but the question is sound mind. When was the power of attorney given? That's the time is when the power of attorney was. Sorry?
Recent, but very old person.
Yeah, old is immaterial. There are very old people who are much smarter and younger than you and me. So it's immaterial. The age is concerned. As long as the act and deed, what he knows, what he did is correct, then you need not worry.
Okay. Thank you.
I think Miss Anita, you asked another question also, no? In the
It was
transfer.
answered. Yeah. Thank you.
So what are the taxes answered? If the purchasers and the power of attorney holder of purchaser both are approved, how can the transfer
I answered that question.
The person who lost his citizenship in Sri Lanka, but whether such person can become an owner to the property by the way of deed of gift in Sri Lanka.
Yes, if he is not a Sri Lankan, whatever the property he has, there is no bar him to hold the property. He can hold and also he can gift it.
Are there any special consideration when leasing property to lessee who is a foreigner?
That's a very good question because you see most of the people are making mistake when these foreigners are coming to Sri Lanka. They get a tourist visa for 30 days or so. So there are instances I have come across where the notaries are doing a lease agreement for 5 years. So they make use of that lease agreement and go and ask him for visa extension. So you have to check and see how far their visa is invalid. Only for that period of time you can do the lease.
If the principal wishes to cancel the power of attorney after giving a notice to the Registrar General, if the principal is unable to physically come to Sri Lanka to execute a deed of cancellation of the power of attorney, can he do the cancellation like a foreign power of attorney?
No, you can't do a power in power. There is a power of attorney in existence. So what he could do is, you see, he has to inform the Registrar General about a cancellation, and as he intend to cancel, he could give another power of attorney. There is no issue, and then can cancel it.
In the question, can he sign the document abroad and send it to Sri Lanka for registration?
No deeds could be executed in a foreign country to attest same here, but any power of attorney could be sent, and then the other attorney could cancel it.
I think the execution now there will be a 2 or 3. It is difficult to get the proper date of execution. It's not clear. Regarding the dates of execution, now there will be a 2 or 3. Difficult.
No, there are instances where you execute a deed on a particular day, and thereafter, subsequently, there can be an attestation to say stamp duty was paid on such and such a day, but for all purposes, the correct date of the deed will be the first day, not the stamp duty date.
Thank you, sir. On behalf of the Bar Association of Sri Lanka, we express our sincere gratitude for taking time out of your busy schedule to deliver this lecture at our request. Thank you once again, sir.
Thank you.